Welcome to another episode on the La Rapport. This is episode 10, and today we will continue with our second episode in this series of commonly used terms in criminal proceedings. And for the usual disclaimer, this is not legal advice. Nothing that I say in this episode should be construed as legal advice. For legal advice, please contact a competent attorney of your choice. We will continue beginning with commonly used terms in criminal proceedings, starting with the letter D. And first, you may hear very often the term defense being used. The defense refers to the accused person's case and the lawyers representing him. So you may hear about the defense team or the defense lawyers or just generally the defense. When you hear that, it is referring to the defense's case and the attorney representing the defendant or accused person. You may often hear the term defense counsel. Who is a defense counsel? A defense counsel is a barrister who represents an accused person in court. We continue with commonly used terms in criminal proceedings, beginning with the letter D, and you will often hear the term defendant. A defendant is the person who is charged with a criminal offense. Another word for defendant is accused. So sometimes this is used interchangeably, accused, defendant. You may hear the term deliberations. Deliberations is the process taken by the jury or the jury panel to decide whether the accused is guilty or not. And how does this work? After the judge sums up the case, the jury then leaves the courtroom, goes into a special room called the jury room to deliberate or to determine whether or not the accused is innocent or guilty. What normally happens is that they review the evidence that was presented during the trial, and then they come to a decision of guilty or not guilty. You may hear the term deposition commonly used. What is a deposition? It's a typed copy of the evidence recorded in court. In other jurisdictions, it may mean something slightly different, but for the purposes of this episode, a deposition is a typed copy of the evidence recorded in court. You may hear the term dock being used, and this is an enclosure court where the defendant or the accused person usually sits during the court proceedings. We now move to commonly used terms in criminal proceedings, beginning with the letter E. You may often hear the term electoral role being used, but probably not in criminal proceedings. Surprisingly, this is a commonly used term in criminal proceedings. What is the electoral roll? It is the list of names of people registered to vote. This list supplies the names of persons who could be added to the jury list for jury duty. You may also hear the term empaneling a jury. This is where a list of names of persons, usually 7, but in capital offenses 12, are chosen from a larger group that have been called to perform jury duty. You will most certainly hear the term evidence being used in criminal proceedings. This is the testimony from witnesses or agreed evidence, such as documents or statements provided to the court, that is used to prove or disprove a fact in the proceedings. You'll certainly hear the word or the phrase or the term evidence in chief or examination in chief. And this is when the prosecutor asks the witness questions so that they can tell the court what happened. And this is not only confined to the prosecutor. The defense or the defendant may also choose to call witnesses, or the defendant himself may choose to give evidence and become a witness in his own case. And so the defense lawyer would then ask him questions so that he will be able to, he or she will be able to present their version of events before the court. That is also evidence in chief or examination in chief. And then you will most certainly hear the word or the term exhibit being used. And this is all other evidence apart from evidence from witnesses needed or used to help present the case to the court. For example, items such as documents, photographs, clothing, or other items relevant to the case or to the matters in issue. We now move to commonly used terms in criminal proceedings, beginning with the letter F. You will often hear the term forensic evidence being used in criminal proceedings. This is evidence found where the crime occurred, or what is known as the crime scene. Evidence such as fingerprints, blood or blood stains, and the DNA, etc. You will also most certainly hear the term forensic medical evidence. And this is where the victim or the accused may be requested to undergo an examination, for example, a mouth swab, in order to provide possible evidence for the case. Then you may hear the term for mention only. So you may hear that a case is for mention only today. What is that? This is where the case appears in court for a brief time, usually to deal with procedural matters such as setting dates, and other case management issues. A mention is not a substantive hearing of the matter. Witnesses are not usually required to attend court when the matter is set for mention only. We now move to commonly used terms in criminal proceedings, beginning with G and H, as we will take these two letters together. You will certainly hear the term guilty in criminal proceedings, and this is to be held legally responsible for a criminal offense. When a defendant pleads guilty, he accepts responsibility for the commission of the offense. A defendant who pleads not guilty may be found guilty by a judge, a magistrate, or the jury. And so, if he is found guilty, then he is said to be guilty of the offense. And if he pleads guilty, then he accepts that he is guilty of the offense. You will commonly and frequently hear the term hearing or hearings used in criminal proceedings. This is any proceedings before the court in relation to the matter, whether or not it is held in the presence of the defendant. You may often hear the term higher court, and this is in reference to a court such as the Supreme Court or the Court of Appeal. You may hear the term hung jury being used in criminal proceedings. This is where a jury whose members cannot agree on the verdict. So there may be a jury of 7 or 12 persons, and they cannot agree. They have different views and opinion about whether or not, based on the evidence presented, that the defendant or the accused is guilty or not guilty. And so if they cannot decide or they cannot come to an agreement, it is said that we have a hung jury. And in this case, the judge will most definitely discharge the jury. In other jurisdictions, this may be referred to as a mistrial, but for the purposes of this presentation and in talks and cases, the jury in this scenario will be discharged. We now come to commonly used terms in criminal proceeding, beginning with the letter I, and you may often hear the term in camera. This is also known as in chambers. A matter may be conducted privately, for example, in a closed court or the judge's private chambers. This is known as in camera. You may often hear the term indictable offenses, and these are serious criminal offenses usually heard in a higher court before a judge and jury. Less serious offenses are heard in the magistrate court. You may also hear the term indictment. And what is an indictment? It's a formal written accusation charging a person with a criminal offense that is to be tried in a higher court. And you may hear the phrase or the term instructing solicitor, but you may not hear it frequently in the Turks and Caicos Islands. And if you remember, in an early episode, I spoke about, for example, in England and Wales, where there are different branches or different types of lawyers, solicitors, barristers, etc. Well, a solicitor is an attorney who helps with the preparation of the case and assists the barrister in court. We now come to commonly used terms in criminal proceeding, beginning with the letter J. And you may often hear the term Justice of Peace or JP. The functions of a justice of the peace includes witnessing oaths, statutory declarations, and other legal documents. A justice of peace is also used where the police may apply for a search warrant to search the premises of someone under suspicion of committing an offense or having stolen property, etc. And there are situations where a justice of peace could be utilized to grant bail to a person in police custody, etc. This has rarely been done, but it could be done. You will hear the term a judge being used. A judge is an attorney. He or she is a lawyer, qualified barrister or solicitor appointed to the position of a judge who is in charge of the court or the case in court, and whose main duty is to ensure that the trial is conducted fairly. Judges usually sit in the higher courts. You will certainly hear of the term juror. And who is a juror? Is a member of the jury. You will hear the term jury being used quite frequently in criminal proceedings. And the jury is a group, usually 7 persons, 12 in capital offenses, chosen at random from the general community, who is tasked with the responsibility of determining whether a defendant or an accused person is guilty or not, and the evidence presented in a trial. The jury determines the verdict, and that is whether the accused is guilty or not guilty. And I use the term capital offense, and I realized that I had not covered that term when I deal with criminal, or when I dealt with commonly used words in criminal proceeding beginning with C. Suffice to say that a capital offense is an offense such as murder, treason, or misprision of treason, and these terms will be explained probably in a subsequent episode. We now come to commonly used terms in criminal proceeding, beginning with the letter L. You may often hear the term legal arguments. This refers to arguments in criminal proceedings between the lawyers on both sides, involving legal matters that are to be decided by the judge. The witnesses and jury are usually absent during legal arguments. You may often hear the term law court in use. This is reference, taking the Turks and Caicos for example, to the magistrate court. But in England and Wales, or the United Kingdom, where the court structure is different, a law court could be a reference to the Crown Court or even the High Court, since the Supreme Court is the highest court in the United Kingdom. Commonly used terms in criminal proceedings beginning with M. You will often hear a reference to a matter in court. What is a matter? A matter is a prosecution or proceeding in court. A case may be referred to as a matter. You will most often hear the term magistrate court. This is a court with limited jurisdiction in criminal and civil matters and has lesser sentencing powers than the Supreme Court. The magistrate usually sits without a jury except when conducting a coroner's inquest. A coroner's inquest is an inquiry into the circumstances surrounding a death, the death of a person. A magistrate is a judicial officer who hears cases in a law court. In the Turks and Caicos Islands, a magistrate must be a qualified lawyer. In England and Wales, they are not legally qualified, but they are assisted in legal matters by a clerk who is a qualified lawyer. And finally, in this episode, we come to commonly used words in criminal proceedings beginning with the letter M. You will most likely hear the phrase or the term mention being used quite often in relation to criminal proceedings. Mention. This is where a case appears in court for a brief time, usually to deal with procedural matters. This may include setting a trial date, giving directions in the case. Witnesses are not usually required to attend court where the matter is for mention only. And you remember when I deal with commonly used terms in criminal proceedings with words beginning with the letter F, I spoke about the term for mention only. Well, there is really no difference between mention in criminal proceedings and for mention. It's basically the same. You may hear the term mistrial. This is a trial that is without legal effect due to errors in the proceedings. And so, if there are errors in the proceedings, the matter is deemed to be a mistrial. You will certainly in criminal proceedings Here the term murder. Murder is the legal term for the intentional killing of someone. And I spoke earlier about misprision of treason. This is a common law offense where someone knows a treason is about to be committed and they fail to report it. And later, when I come to deal with commonly used terms in criminal proceedings, beginning with the letter T, I will deal with treason. You will often hear in court the term my learned friend. It's a phrase that is customarily used by lawyers in courtroom when they refer to opposing lawyers. And so we come to the end of this episode. I hope that I have been of some assistance to you, and I will continue subsequent episodes in commonly used terms in criminal proceedings. I believe that I will have to do about 2 more episodes to complete the series of episodes commonly used terms in criminal proceedings. I thank you very much for listening. Thank you.